My name is Luke Gittos. I'm going to be taking you through these online webinars, which are designed to give you practical insight into the areas of law and the institutions that you're going to be working on when you're looking at your casework. Now, a couple of caveats before we get started. These shouldn't be used as exam revision materials, nor should they be considered comprehensive accounts of the law in any particular area. If there are any lawyers watching, then I can guarantee that it will skip over things you think might be relevant. But really, these webinars are intended as a practical guide to give you the means to start engaging in a meaningful way with the casework that we send you. So please, no complaints as to what might have been missed out or skipped. These are really practical guides to allow students to get started on their work. So without further ado, let's get started. In this first lecture, we're going to be looking at really the key institutions and legislation which you're going to be looking at over the next 6 weeks. This first lecture is split into two. In the first part, we're going to be looking at the Crown Court a little bit, and then the progress up into the Court of Appeal, which is where we're going to spend most of our time. Then in the second part of this lecture, we're going to be looking at grounds of appeal, and then also the Criminal Case Review Commission, which is the institution you're actually going to be working with. But for various reasons that will become clear throughout this lecture, it's important that we consider the Court of Appeal first before we consider the CCRC. Okay, so the first institution we have to consider is the Crown Court, because all of your clients will have been through a Crown Court trial. The Crown Court is where the most serious cases in England and Wales are dealt with. They don't deal with very many offences in the context of the criminal justice system as a whole. I think that about 5% cases are actually dealt with by the Crown Court. 95% of cases are dealt with in the Magistrates' Court because they're not sufficiently serious for attention at the Crown Court. However, all of the clients that you will be dealing with have gone through a Crown Court trial and would have been found guilty of a criminal offence. Obviously, in England and Wales, there's only two possible outcomes to a criminal trial. That is, someone is found guilty or they're found not guilty. The situation is slightly different in Scotland, but we're not working on any Scottish cases. So your client will have been found guilty of a criminal offence in England and Wales. And that means the technical term is that they've been convicted of a criminal offence. Convicted is merely a technical term for the fact that they've been found guilty of a criminal offence. And in all the cases you're going to be doing, they would have gone on to be sentenced to very long sentences. Indeed, in many cases, they will be serving life sentences for the offences that they've been convicted of. So what we're going to do is imagine a hypothetical client who has just been convicted of murder. And the first thing they're going to want to know is whether there is any basis on which they can challenge or appeal their conviction. So effectively to set aside the conviction that they've just received. So counsel's duty, first off, is to give an indication to the client as to whether or not they think that the client has any grounds on which to appeal their conviction. Now, the word counsel here obviously doesn't mean the local council or your local authority. It's just the technical lawyer's word for a barrister whose job it is to present the client's case in court. So the barrister's or counsel's duty is to provide, at least initially, after the defendant is found guilty, they'll go down to the cells to see their client, and they'll give probably an oral indication as to whether they think there is any grounds to pursue an appeal in their case. Let's assume that our barrister in our hypothetical case does think that there are grounds to appeal. He or she will then have to go away and prepare a document which will set out his or her advice on whether they think the defendant can mount an appeal. And assuming that they do, assuming that the barrister concludes that there is a legal reason why the conviction should be challenged, he or she will prepare what are called grounds of appeal. And grounds of appeal are really just another word for the formal document that will go in front of the Court of Appeal to help them decide whether or not the appeal should be granted or allowed. Now, you're going to hear a lot of different words for the same thing. So words like granted, allowed, grounds of appeal, advice on appeal. And I'll do my best to clarify on the way through what the difference between these things are. But often the words are expressing a distinction without a difference, and really they amount to the same thing. But the first one I want to draw attention to are grounds of appeal and advice on appeal. Often these two things are referred to the same thing. When a barrister expresses a view as to whether a client can appeal their conviction, they are obliged to set out a written advice on appeal, which is a written document setting out whether they think there are or are not grounds for appeal. If they think that there are, they will develop grounds of appeal. Grounds of appeal are what go into the Court of Appeal for them to consider the appeal. So the difference between an advice and grounds is that an advice can be a written advice indicating why the barrister does not think there are any grounds of appeal. If the barrister goes on to settle grounds, they have concluded in the course of their advice that there are grounds of appeal to pursue. So really the difference is between an advice on appeal and grounds of appeal is that grounds of appeal is an indication that the barrister thinks that there is grounds to pursue an appeal against conviction. So if you hear refer to a grounds of appeal, it will refer to a document setting out the positive reasons why he or she thinks that an appeal should be pursued. So let's assume that our hypothetical barrister has concluded that there is a legal basis to challenge the conviction. They will then proceed to settle grounds of appeal, and the grounds of appeal will have to be sent with what's called a Form NG. It's not a very consequential form, but I can show you it in the course of our casework sessions if you like. A Form NG to the Crown Court where the client was convicted. Now this aspect is a little bit counterintuitive. The papers do not go straight to the Court of Appeal. They get sent to the Crown Court where the client was convicted. So if the client was convicted on a trial at Cardiff Crown Court, the papers do not go straight to the Court of Appeal. They get sent first to the Crown Court at Cardiff where the client was convicted. And the client, importantly, has 28 days from the date of his or her conviction to lodge an appeal. So 28 days from the date that that guilty verdict was entered to lodge that Form NG and grounds of appeal. Now, defendants can also appeal against their sentence. They can say that we think the sentence was too long for whatever reason. But we're not going to look at sentence appeals at all in this course because we're not going to be doing any work on sentence appeals. However, it's worth noting that if you are appealing against someone's sentence, then what is required is for them to submit the paperwork 28 days from the date of sentence rather than the date of conviction. So the law says that from the date that the ruling that you are trying to appeal, you have 28 days, whether that be the finding of guilt, i.e. the conviction, or the passing of sentence. And we can discuss appeals against sentence, if you like, in the course of our casework sessions. Okay, so the key piece of legislation we're going to be looking at, which governs the appeal process, is the Criminal Appeal Act of 1968. And it's section 1 of that act which creates the right of appeal, the right of a defendant to appeal their conviction. So under section 1 of the 1968 Criminal Appeal Act, it reads, subject to subsection 3 below, a person convicted of an offence on indictment may appeal to the Court of Appeal against his conviction. I'm afraid that all statutes in this country use the word his rather than his or her. So if I accidentally refer just to him or his, there's nothing sexist about it. It's merely that is the way that the law is drafted for whatever reason. So section 1 under right of appeal. Let's just break this down a little bit. Subject to subsection 3 below, a person convicted of an offence on indictment may appeal to the Court of Appeal against his conviction. So a couple of points I wanted to pick out here. We remember the meaning of the term convicted. They've been found guilty of a criminal offence. And this word here, on indictment, the words on indictment merely indicates that this particular right of appeal refers to the right to appeal from the Crown Court. An indictment is the document which sets out the charges that a Crown Court trial proceeds on. It's a formal document that is deployed only in the Crown Court and not in the Magistrates' Court. So that means that this right of appeal creates a right with respect of a person convicted of an offence on indictment, indicating that it creates the right for the person convicted in the Crown Court. And obviously the rest of that is pretty straightforward, may appeal to the Court of Appeal against his conviction. So it's section 1.1 that creates that right to challenge their conviction in the Court of Appeal. The important section here is section 1.2, and that reads that any appeal under this section lies only with leave of the Court of Appeal, or if within 28 days from the date of conviction, if within 28 days from the date of the conviction, the judge of the court of trial grants a certificate that the case is fit for appeal. You see that little if sneaking in there between the B and the rest of the sentence. Now, we're not going to focus on this because in none of the cases we're looking at will section 1.2b be relevant. In no case will, in the cases that we're looking at, will a judge have granted a certificate saying that the case is fit for appeal. Instead, what the process that we have to look at is section 2a, where the court has to grant leave of the Court of Appeal to appeal. So let's break this down. What this section is saying is that a defendant can only appeal to the Court of Appeal if they receive leave to appeal. Now, the word leave is just another legal term, and it refers to permission, the permission to appeal. So you can pretty much use those words interchangeably, leave and permission. So what this section says is that an appeal to the Court of Appeal can only proceed with leave or permission of the Court of Appeal. So what this section does is create really a two-stage process for the Court of Appeal. The first is the consideration as to whether an appeal should have leave. And an applicant has to have leave to appeal before they actually appeal. They have to have permission. And then obviously the second stage is the appeal itself. So the first stage is granting leave to appeal, and the second is the consideration of the appeal itself. And we'll see that that process has a particular, there is a particular process associated with both those stages. We're not going to worry too much about these sections here because none of them will relate to the cases that you're going to work on. The key distinction to take from section 1 is the difference between the process of granting leave and the process of appealing. You need leave of the Court of Appeal to appeal your conviction. Okay, so this is section 2. I know that the 2 has been missed out of the slide, but this is section 2 of the Criminal Appeal Act of 1968. And this will take us into a little bit more detail. So under section 2, it gives the grounds for allowing an appeal under section 1. So subject to the provisions of this act, the Court of Appeal shall allow an appeal against conviction if they think that the conviction is unsafe, and shall dismiss such an appeal in any other case. This arguably is the most important component of the 1968 Act, or at least one of the key components, because what it does is that it says that there really is only one basis upon which to appeal a conviction. There is only one ground on which a conviction will be quashed, and that is if a conviction is unsafe. Now, this is really the key word that you need to take away from this opening webinar, the word unsafe, and I'm going to underline that there. So the word unsafe is pretty central to all of our work. In all the work that you do, you're going to be considering whether or not a conviction can be said to be unsafe, whether the work that you have done points to the possibility that the conviction is unsafe. And that really is the only thing that matters. You can raise all sorts of doubts about a particular case. You can say, well, why didn't they investigate this? Why didn't they investigate that? And if you're here because of shows like Making a Murderer and Serial, those programs and podcasts do those things very, very well. They create doubt about a particular aspect of a case. But all of that will be irrelevant unless you can get over this hurdle of demonstrating that the conviction is unsafe. And obviously we'll come to look at what that means in more detail later on. But for the time being, I just want you to have that absolutely clear in your mind. The only basis upon which a conviction will be set aside is if the conviction is unsafe. Prior to the passing of the 1968 Act, there was a whole host of different common law reasons, i.e. Judge-made reasons why a conviction could be quashed. But the 1968 Act sought to consolidate all those common law reasons and replace them with this test of a conviction being unsafe. And although some of the reasons that the Court of Appeal have concluded that a conviction is unsafe reflect those old common law rules, the important thing to recognise is that the Criminal Appeal Act put it on a statutory footing for the first time and created this single ground of appeal, which is where the conviction is unsafe. And importantly, the court shall dismiss such an appeal in any other case. So that's saying that unless the appeal shows that the conviction is unsafe, the appeal will be dismissed. Going on to section 2.2, in the case of an appeal against conviction, the court shall, if they allow the appeal, quash the conviction. So here's the word allow. So that the word allow, I'm just trying to underline that. Don't worry. Trying to underline the word allow. There we are. So the word allow is really just another word for granting or the appeal succeeding. So looking at the structure of this section, the Court of Appeal shall allow an appeal against conviction if they think that the conviction is unsafe. And if they allow the appeal, they will quash the conviction. So the end point we are aiming for is quashing the conviction. So let's have a think about that. The key point is that the court shall allow an appeal if they think the conviction is unsafe. And in the case of an appeal against the conviction, the court shall, if they allow the appeal, quash the conviction. So you can see those two stages, allowing the appeal, and if they allow the appeal, they shall quash the conviction. And then on section 3, an order of the Court of Appeal quashing a conviction shall, except where under section 7 below the appellant is ordered to be retried, operate as a direction to the Court of Trial to enter instead of the record of conviction a judgment and verdict of acquittal. So that's a very long way of saying that if the appeal is allowed, the quashing of the conviction, which follows the allowing of the appeal, will act as a direction to the court below to enter a verdict of acquittal rather than of conviction, which means has the legal effect of effectively quashing the verdict of the jury. Unless, of course, section 7 is applied and the appellant is retried. And in many cases where there is a successful appeal, there will be an order for a retrial. Very rarely is an appeal, a successful appeal and a quashing of a conviction, the end of the story for a defendant. It's only where new evidence or something similar is demonstrated that a defendant has to be innocent that there will be no retrial. Okay, so let's go back over what we've looked at. So there is now only one ground of appeal under the 1968 Act, and that is that the conviction is unsafe. I won't underline it again, I think you get the idea. Once the appeal has been lodged at the Crown Court, it will then be sent to the Court of Appeal. Now, just looking at this procedurally, once it's been sent to the Court of Appeal, obviously within the 28-day time limit, as discussed, the registrar of the Court of Appeal will be responsible for the administrative management of the appeal. So the registrar is effectively an individual at the Court of Appeal who is in charge of managing the administration of the appeal. He or she will set the key dates, will prepare the important paperwork. But the first job of the registrar is to prepare the papers for the first key person we're going to meet in our appeal process, and that's the single judge of the Court of Appeal. I am terrible at underlining things. That's more of a highlight. So the papers will be prepared for a review by the single judge of the Court of Appeal, and the registrar will be responsible for preparing those papers. What happens next is that the registrar, just seeing someone come to my door, I had to shoo them away. So the registrar of the Court of Appeal will be responsible for the administrative management of the appeal. The papers will then be prepared for a review by the single judge of the Court of Appeal. Now, the job of the single judge is to decide whether or not the case should have leave, okay? Should decide whether or not the case should have leave. Now, remember we talked about leave in the last section, and that is the leave is another word for permission to appeal. So he or she will be responsible for deciding whether or not the case should have leave. Now, the single judge, there's no magic to that phrase. The single judge of the Court of Appeal is just a single Court of Appeal judge, and they will review the papers as prepared by the registrar and by the barristers, and consider whether or not the case should be granted leave. If the case is granted leave, the judge will forward the case onto the full court to hear the substantive appeal, to hear the appeal itself. But let's consider what the single judge does. They prepare a single sheet of paper called a Form SJ, and we'll be seeing Form SJ in the course of working on our casework. But what a Form SJ does is sets out the reasoning of the single judge as to whether they think there are grounds, whether the grounds that have been submitted should be granted leave or permission to appeal. If they refuse, the single judge will read the papers, and if they refuse to grant leave, they will explain why in the Form SJ, and they will send the Form SJ out to the appellant and their lawyers. And the Form SJ will set out clearly why the single judge does not think the appellant should be granted leave. Now, the applicant then has the appellant or the applicant then has the ability to renew their application for leave before the full court. So if they are refused permission to appeal by the single judge, they can then renew their application for permission in front of a court, and that involves simply signing the back of the Form SJ and sending it back to the Court of Appeal. And if they do that, they are then entitled to have their application for leave determined by 3 judges of the Court of Appeal in a full hearing. And the barristers will go along and argue as to why the single judge made a mistake. Now, in practical terms, what that means is that if you go along to the Court of Appeal and you look at the listings, you'll see 2 kinds of hearing timetabled. The first will be substantive appeals, and usually they take at least half a day or a day to be heard. Or you will see renewed applications for leave being timetabled. And what that will mean is that the applications for leave will be far shorter. So renewed applications for leave often take about 20-25 minutes, and then the judges will usually give a ruling there and then as to why they either agree or disagree with the single judge. And it may not surprise you to know that in most cases, renewed applications for leave simply result in the Court of Appeal judges agreeing with the single judge that the case should not be granted leave. So assuming if they do not make a renewed application for leave, then that is the end of the case and the appeal is disposed of. If they do make a renewed application for leave, then the full court will hear the application and decide whether or not the case should or should not be granted leave. If the case is granted leave, then it will be listed on a separate occasion for a determination of the full appeal. And once the case is in front of the full court, once permission has been granted, the judges will go on to consider whether or not the appeal should be allowed and whether the conviction should be quashed. And that's what we're going to look at in the following lecture. So see you there. Thanks very much.